said, we'll be discussing preparing for an eviction trial and going over settlements and the UD process. Okay, so here's today's agenda. Like I said, we'll be looking at the notice, types of notice, and the UD process. We'll also be looking as to what do you want to do. This is in regards to what outcome do you want for your case, and we'll be looking at negotiating and settlement agreements. And lastly, we'll take a look at the UD trial. Okay, so if you receive a notice from your landlord, for the most part, when a landlord wants to evict a tenant, they must give a written notice to their tenant. So this means you can't, no, your landlord can't give you a notice via email or text it to you. It has to be in writing. There are three types of service. This means three ways they can serve the notice. It can be a personal service, which means the landlord or somebody who works for the landlord hands you the notice. It can be post and mail. This is when a copy of the notice is posted to the property, and then a copy is also mailed to the resident. Substitute service is referring to the notice being left with a household member who is at least 18 years old, and a copy of the notice is then mailed to the resident. Type of notice a landlord can serve. These can include a 3-day notice to pay rent or quit, which is when the landlord is demanding you pay rent. A 3-day notice to cure or quit. This is when the landlord wants you to fix a violation of the rental agreement, right? It can be like removing trash from the property, or it can also include the landlord asking you to stop doing something, right? Like stop making too much noise. Another notice they can serve is a 3-day notice to quit. And this is when the landlord wants you to vacate the property within 3 days for something that you might have done that can be cured or fixed. Another notice they can give is a 30-day, 60-day, or a 90-day notice. And these are notices that will let you know you have 30 days or 60 days or 90 days notice to move out. Usually 90-day notice, those are usually reserved for Section 8 tenants. And regarding these notices, they have to have a reason listed on them in order for them, depending on where you live, and they may require a reason to be stated on the notice. Okay, so what happens after you receive a notice? If your landlord claims you didn't comply with the notice and the notice has expired, right? So if you received a 30-day notice and 30 days have passed and you didn't do what the notice says, then the landlord's next step will be to file what's called a summons and complaint with the court or unlawful detainer. The document to the left is the summons, right? It's a 2-page document. And this one's important because if you read it, if you do receive it and you read the first paragraph, it will tell you you have 5 days to respond to the unlawful detainer, right? It'll tell you that Saturdays, Sundays, and judicial holidays do not count within those 5-day period. And the document to the right is the complaint. And this is where the landlord will be making statements like who are the parties regarding your tenancy, what type of notice was given out, when the notice expired. Sometimes the rental agreement will be attached to the complaint, and that's usually marked as Exhibit 1. The notice that you received would also need to be attached to the complaint, and that's usually labeled as Exhibit 2. Okay, so if you do receive a unlawful detainer, you can go ahead and go to one of these self-help centers so they can provide you assistance with filing or completing an answer with the court. I'll leave this up for a while so you guys can take a look at maybe what court is near you, so you can, in case you do receive a unlawful detainer. And if you do receive a unlawful detainer, again, it's important you file within 5 days of being served, right? Because if you don't, then the landlord can file what's called a request for entry of default, which we'll be taking a look in the next slide. Okay, so this is the eviction process, right? As you can see, the first step will be for the landlord to give their tenant some type of notice. Once that notice has expired and the tenant not complied with it, then the landlord's next step is to file a summons and complaint, right, or unlawful detainer with the court. Once they serve that unlawful detainer to their tenant, the tenant will then have one of two options. The first option will be to file a answer with the court, right, within 5 days of being served, or they don't do anything, right? And you don't want to do anything because, like I said, if you don't file a response with the court, then the landlord can file for a request for entry of default, right, which would be on the right-hand side of this graph. And then once the request for entry of default is entered, then, and the judgment is also entered, then the tenant will be receiving a 5-day notice to vacate from the sheriff's, right? And this usually happens after the default judgment has been entered and the landlord files what's called a writ of possession. They'll take the writ of possession to the court. Once the court grants it, they'll take it to the sheriff, and then the sheriff will go post a 5-day notice to vacate. If the tenant does file an answer, which that's going to be on the left-hand side of the graph, right? After the tenant files the answer, the next step goes to the landlord. Usually they will request a court date because court dates aren't automatically set in these cases. They have to be requested. Usually when the landlord makes the request, a court date is set within 20 days of that request being made. And once a court date has been set, then the court will mail out a notice to the parties involved, letting them know the date, time, and department number their court date is set for. Okay, so now you've been served a unlawful detainer, and what do you want to happen in your case, right? So this is in regarding what outcomes do you want, right? Do you want to stay and pay, or do you want to move out, right? Some questions you may want to ask yourself are, how strong is my case? Do I have good defenses? Do you have some type of leverage against the landlord to get the case dismissed or to maybe get a better move out deal? If you are maybe thinking of doing like a move out deal, some questions you can ask yourself are, how long will it take me to find new housing? Another question you can ask yourself is if you can fix your relationship with your landlord, right? If you think you can, right, then you may want to stay in the unit. If you don't think you can, or if the landlord's harassing you and you just want to move out, then you can plan like for a move out. The other thing you can ask yourself is if you can pay the rent that's owed, or if you can still even afford pay the rent for the current unit. Okay, so what are your options? So you can negotiate, right? If you negotiate a deal, you must have it in writing and have both parties sign it and file it with the court. Right. So this will either be like a pay and stay or a move out. Your other option is to go to trial and take a risk to see if you can win your case. Or the third option is move out before trial. right? If you have somewhere to move to, maybe this is a option for you, right? So if you do decide to move out before trial, you can return the key to your landlord, but you want to get a receipt for when you turn your keys to the landlord. If you do, you can go to the court and tell the judge that you moved out, right? You want to bring your proof, right? So that that can be like the receipt that you got from the landlord, where they admit that you returned the keys and are no longer have possession of the property. It can be a new rental agreement or a change of address with the post office. If you move out before your trial, the landlord cannot evict you, but they can still sue you for the money that's owed if there's any money that they are requesting. Right, so some landlords may still be able to identify the case, an eviction case, by the case number, right? And the other thing is, you do not want to sign anything or enter into a settlement agreement for money owed if you do move out. Okay, so if you want to negotiate a pay and stay, you should be ready to pay all or most of the rent money that's owed. Be prepared to pay the landlord's attorney's fees and court costs. Attorney fees can only be collected if the rental agreement allows for it. So usually in the rental agreements, it will say the prevailing party is entitled to attorney's fees if they bring the an eviction case forward. You also want to bring any evidence that can help you negotiate less money owed, right? So proof of bad conditions, this can be like a report from a government agency, like the health department or building safety. It can also be pictures, right? You can bring proof of landlord's harassment or any proof of disabilities. That this can also help you. And if you do not have all the money, you can ask for a payment plan, but be careful because if you miss a payment, if you settle to make with a payment plan and you miss a payment, right, then you are in breach of that settlement agreement, in which case the landlord can then proceed with the eviction process. So if you do enter a payment plan, you want to make sure that you are able to keep up with the payment plan, right? Because it's going to be a payment on top of your other monthly expenses. And you can ask for the case to be dismissed and the record to be permanently sealed upon completion of payment. In this way, the case doesn't affect your rental credit. Okay, so if you want to negotiate a move-out deal, what you want to take into consideration is how long will it take you to move? How long will it take you to find new housing? You may want to ask for at least 30 to 60 days from the move for a move-out deal, right? This is just in case you do find new housing and something goes wrong. You do have this cushion of time to try to find new housing. You want to ask your landlord to let you keep any past due rent, right? So this is referring to if you owe any rent or if you're going to keep or allow you to keep any rent until you are moving out of the unit, right? Attorney's fees and court costs. Again, attorney's fees can only be collected if your rental agreement allows for it. We recommend you demand or negotiate waiver of all the back owed rent and any rent until you move out. Right, so this is like I said before, you want to ask the landlord to let you keep any unpaid rent if you have it, right? Same thing with any future rent until you move out. And so you can use this money to help you for a security deposit or for moving expenses. And you want to also bring any evidence that can maybe help you negotiate for more time or for less money that you owe. Right, again, this is proof of bad conditions, right? Pictures, government reports. And one thing with a move-out deal, you may consider giving up your security deposit to try to persuade the landlord to to give you more time to move out. And you can also ask for the case to be dismissed after you move out and for the record to be permanently sealed. Okay, so now we'll look at if you do get your settlement in writing. This is the document that we'll be looking at. Okay, so this is the document where you will be writing your settlement agreement in. We'll be looking at into each sections, right? But the settlement agreement form is a 3-page document where you will write the terms of your settlement agreement. Okay, so on the first page at the top, you'll have the caption box, and this is where you want to write the court's address. You want to write the plaintiff's name where it says plaintiff. The plaintiff is usually the landlord. If you're not sure who the plaintiff is, you can take a look at the complaint. The defendant, this is going to be you. So you're going to write your name here. And you want to spell it the same way as it's on the complaint, even if it's misspelled. Usually if it doesn't match how it's written on the complaint, the court may not want to take it. And obviously you also want to include your case number. Okay, so for part 1, this is where you will write the address of the property. Again, this needs to match the address listed on the complaint. If it doesn't match, then the court may not want to take your settlement agreement. So just be careful that it does match. And underneath number 1, there's a box that says defendant's rights under lease or rental agreement are forfeited. And if you agree to move out, then you can mark the box. Or marking the box, you agree that you're forfeiting your rental agreement. Okay, so for number 2, this is if you agree to pay the landlord any money, then this is where you're going to put it, right? You're going to include the amount of rent you agreed to pay. You'll include the amount of holdover damages. Holdover damages is the rent that hasn't been paid since the notice expired. Again, you will also include, if you agree to pay the landlord's attorney's fees, then you will list the amount there. And again, in order for a party to collect attorney's fees, the rental agreement must allow for it. And you'll also include cost for the plaintiff, and the cost will just be like a filing fee or any other fee that they pay to like file documents with the court. So all of that amount will be listed in number 2. Okay, so now for number 3, this is in regards to your security deposit. If you guys agree that you will be keeping your security deposit, then the landlord has 21 days to return that deposit to you from when you vacate the property. If a landlord makes deductions from your security deposit, then they have to give you a itemized list as to why they made those deductions to your security deposit. And you can dispute any deductions made from your security deposit, either in small claims court or in civil court. Small claims court is anything for up to $10,000. Civil court is anything above $10,000. If you agree that your landlord can keep your deposit, then you want to mark the second box in number 3, right? And that way, the court will know your landlord can keep the deposit and you're waiving any right to have it returned to you. So number 4, this is in regards to when the judgment shall be entered, right? So it can be either now or it can be now and say enforcement of the judgment as follows, right? So this will require for a writ of possession to be issued, right? So if the second box is marked, you want to include the date that you agreed to move out. So for example, if you agreed to move out on December 31st, then on this line in the second box, you will include you will write the following date, right? So if you agree to move out December 31st, then you will write January 1st. The third box, it's in case there is a breach of the settlement agreement, right? So if you guys come up with an agreement and you breach that settlement agreement, then the landlord can then go ahead and ask for the judgment to be entered and to proceed with the eviction process, which we'll take a look in a few slides. Okay. And number 5, if you agree to move out, and then this is where you will be writing the last date that you agreed to be there, right? So if you agree to be there December 31st as your last day, then that's the date you're going to write here, right? And you also agree to remove any personal or remove anybody else that's living there at the unit. Okay, so for number 6, this is where all the terms of the settlement agreement will go, right? So whatever terms you agree to, they need to go in number 6, and then it must be followed exactly, right? Because if you don't keep the settlement agreement, then you are in breach of the settlement agreement, in which case the landlord can proceed with the eviction process. Right, so there's not going to be any trial date or anything like that if you guys enter into a settlement agreement and then you breach the settlement agreement. So whatever terms you agree to, they'll go in number 6, and you want to make sure that you understand the terms you are agreeing to. Okay, so now we'll look at number 7. And so number 7, this is where you will be writing a payment plan if you agree to pay the landlord any type of money, which would be listed in number 2, right? So again, you want to make sure that you are able, if you do agree to pay the landlord any type of money, that you can make those payments, right? And so whatever payment plan you come up with, that would be included in number 7. Okay, and now we'll look at number 8 and 9. So number 8 is the waiver of rights, and the rights that you would be waiving would be the right to be represented by an attorney, right? And the right to receive notice in case the other party needs to go into court to let the court know that you breached the settlement agreement. In number 9, you would complete number 9 in case you use an interpreter. If you don't, then you can leave that blank. Underneath number 9, this is where you will put your name, the date, and then you'll sign it. And underneath your signature, you will mark whether you're the defendant. Okay, and then this is on the 3rd page, but this is what the judge will complete. So you don't need to mark anything here, but this is important because it tells you that once the settlement agreement is signed by both parties and is entered into court, the settlement agreement becomes final, so it cannot be changed. So it's important that you comply with all the terms of your settlement agreement, right? Again, if you are in breach of your settlement agreement, the landlord can proceed with the eviction process by getting a writ of execution or possession, and which in turn can get the sheriffs to lock you out of the property. Okay, so now we'll look at the trial process. So how you can prepare for trial. Okay, so after you filed your answer with the court, like I mentioned before, court dates aren't automatically set. They have to be requested. So the landlord can do that by filing a request to set case for trial. Usually once the landlord or their attorney has filed it, the court will set the court date within 20 days of that request being made. Your attendance is mandatory for your court date. If you miss or you are late to your court date, default judgment can be entered against you. And if you filed an answer and haven't received any notice of trial or anything from the court, it's important that you follow up with the court to check if you have a court date has been set. Okay, and here are some phone numbers that you can contact if you have a case and you want to reach the clerk at your court. Okay, so preparing for your court date, you can do this by preparing your evidence, right? So you want to make at least 3 copies of any evidence, any document or picture that you're planning on using at trial. You want to make at least 3 copies of it. So you want to have an original and at least 2 copies, right? One for the court, one for the other side, and you want to keep the original for yourself. Right? You can also consider bringing any certified reports, pictures, letters. You can also consider bringing proof of payments, right? Which rent receipts, copies of checks or money orders. If you are planning on having a witness testifying on your behalf, that witness must be in person, right? So they need to testify in person. They can't write a statement for you and try to use that at court. If you're not sure if your witness will show up at court, you can file a subpoena for it to get them to appear. And this way, it will ensure that they are there at court. If you subpoena your witness, though, the witness can ask you to pay their mileage and witness fees. The other thing, when you're preparing for your court date, is that the court will not give you additional time to collect evidence or to prepare for trial. Okay, so if you receive your notice of unlawful detainer trial and your court date has arrived, right? You want to arrive early, right? Again, if you miss your trial, a default judgment can be entered against you. You want to dress to impress, right? You want to let the judge know that you're taking this serious. Some courthouses do have child daycare, but you want to check in advance with your court, right, to see if that's something that's available, because children aren't allowed in the courtrooms. And then you also want to bring your evidence, right? So again, you want to bring your 2 copies and your original. You want to bring your witnesses. And if you need an interpreter, you want to bring them as well, right? And when you arrive at your department, you want to check in with the clerk or with the bailiff that's there. And you just want to let them know that you're present, right? So that the judge knows that you're there. You also want to turn off your phone, and then you will want to sit there until your case is called by the judge. Once the judge calls your case, then you can stand up and go forward. Okay, so once the judge has called your case, the landlord or the plaintiff will go first, and they will be, either be calling their witness to explain why you should be evicted, or they will testify, right? And when their witness or they're testifying, you can take notes as to what they are saying. And if they are lying, you don't want to react to their statements, even if they are not true, right? You can just keep taking your notes. After the plaintiff finishes with their witness or they finish testifying, then you can cross-examine them, and this is where you can ask them questions. The purpose of you asking questions is not to tell your side of the story, but to challenge the testimony that was given. And if the landlord is using documents or photos as evidence, they must give you a copy before they give them to the court, and you have the right to review the original document. After the landlord has presented their case, then the judge will give you a chance to present your case. And this is when you want to tell the judge your side of the story, right? You want to be brief and straight to the point. You can make an outline of the events or of your argument so that you don't forget key events. The judge may interrupt you to ask questions. And after you finish testifying, the landlord or their attorney can then cross-examine you, in which case they would be asking you questions in regards to your testimony. And now we'll look at how you can present your evidence. Right, so you want to mark your photos or other evidence for identification right before the trial. Usually for defendants, you can use the number starting from 101 and so on. You can offer all of your exhibits into evidence. The other side can deny or try to not get your evidence into court, and the judge may or may not accept some of your exhibits. After both parties have given their side of the story, the judge may allow you guys to make a final statement at the end. And in your final statement, you should tell the judge why you should win the case, why the facts support your defenses and not the landlord's facts. And lastly, the judge cannot make a decision based on the fact that you have a family or you are sick or that you have no place to go. Okay, so when the court is ready to give their decision, you can ask the court to give you a statement of decision before the judge gives the ruling. And this just explains the reasons why you either won or lost, and it's usually in writing. You can expect an oral decision, right? The judge is not required to give a written decision if trial lasted less than a day or 8 hours. The judge will usually give you their decision while you're still in court, but they may also mail you their decision. If they tell you they're going to be mailing it, it usually takes a few days after the trial. Okay, so the court's decision should contain the following. It should tell you whether the judgment was entered in against you or for you, right? So if it was entered against you, then the landlord won, and you will need to move out. Or if it's entered for you, then you won the case and you can stay in the unit. If the decision will also tell you if you have to pay back rent or don't have to pay anything. It would also tell you if you need to pay attorney's fees and cost. Again, usually for attorney's fees, it needs to be in the rental agreement. If you are self-represented, you cannot get attorney's fees. Okay, if the court decides in your favor, right, so you win, and if you win based on a habitability defense, in which meaning that there are bad conditions in your unit, right, then the judge may order you to pay at least a portion of the back rent, or that you pay the rent within 5 days. If you pay on time, then you do not have to move out. But if you miss the deadline the judge gives you, then your landlord will win and you will have to move out. If you win, the judge does not make you pay back rent, the landlord may serve you with a 3-day notice to pay rent or quit, right? So they would be restarting the eviction process. And if you do not pay the rent or do not move out, then again, your landlord may start the eviction process over again. Okay, so if the court enters judgment against you, right? So this means you lose at court, then the judge then you may ask the judge to give you additional time to vacate the premises. You will need to explain to the judge why you need that additional time. The judge may ask you to pay for that additional time, right? And if the judge does not give you more time, you don't have to move out that same day of your trial. The landlord still needs to file what's called a writ of possession, and then they'll take that writ over to the sheriffs. Once the sheriffs get the writ of possession, then they can serve a 5-day notice to vacate. And once the sheriffs post that 5-day notice to vacate, then you will need to start planning to move out. But even if your landlord is to win at court, they cannot forcibly lock you out of the unit. If they do, you can contact the police to file a report regarding a illegal lockout. So if the sheriffs give you a 5-day notice to vacate, then you will have 5 days to vacate the property. If you're still there after the notice to vacate has expired, then the sheriffs can perform a lockout, in which case the locks to the unit will be changed, and they'll tell you you cannot come back or you would be trespassing. The sheriffs won't give you time to pack your things, right? So if you take any medication or you're trying to find important documents, right? The sheriffs aren't going to give you time to do that. They can just show up and say, hey, you have 1 or 2 minutes to get what you can and move and get out, or they can just show up and say, get out, right? In which case you would need to vacate the property. If you are locked out by the sheriffs, then you have 15 days to contact your landlord to set up a date so you can go pick up your personal property that was left behind. If you don't, the landlord can dispose of it however they want, right? They can either keep it, sell it, or they can throw it away. The other thing that happens when the sheriffs perform a lockout is the court will lose jurisdiction in the matter. So it's very unlikely that you will regain possession of the property. Okay, so that is it for the presentation. And so thank you for joining us.